This is case 2023-0076, Hate to Paint LLC versus Ambrose Development LLC et al.
Good morning. For the record, Justice Donovan is disqualified on this case. Attorney Gordon, I understand you reserved 2 minutes.
Thank you. May it please the court, I'm Joshua Gordon. I represent Ambrose Development and the Flatley Company, builders and owners of commercial properties who are here this morning. Two experienced commercial operators negotiated a contract that contained a termination for convenience clause, which are prevalent and maybe even ubiquitous in the commercial construction industry. When Ambrose exercised the clause in compliance with its terms, Hate to Paint now wishes it negotiated a different deal. But Hate to Paint signed the contract, and that should just be the end of the story. Obviously, a covenant of good faith and fair dealing is implied in the background of every contract, but the termination clause here was a negotiable term, making it non-susceptible to the bad faith analysis under Centronics. Bad faith is when a party undermines performance while purporting to perform, like subverting the contract or tanking it, such as a city not applying for funds to fund the contract, in Rochester case, or an insurance company delaying payment to pressure settlement in Lawton, or a leasing firm not hiring out the cars on which the other party was paid by the mile. That's subverting the contract. Here, Ambrose did nothing to subvert or tank it. It merely conducted a routine audit and found an anomaly. Around the same time, a better offer walked in the door, and getting a better price alone is not bad faith. The argument that my brother makes in his brief that Ambrose should have waited until performance began, that would have been bad faith, perhaps. But Ambrose terminated early as soon as it realized the problem, so Hate to Paint had maximum time.
Maximum time? How much time was that?
Well, the performance was supposed to start sometime in 2020. This contract was signed in August 2019. The termination letter was sent the 3rd of January 2020. Performance was supposed to start sometime in 2020.
So should it be relevant to our analysis how close that termination letter was sent to when the performance was to have begun?
It's unclear when performance was supposed to start. I think these are construction projects where you have to move in the different crews, and the painting crew is very close to the end of the project. So the point is that the waiting until performance started would have been worse for Hate to Paint, and so it seems to the argument that that waiting until performance would have obviated the bad faith just seems upside down to me.
Why isn't the agreement an illusory agreement? It seems it doesn't really bind your client. You're saying your client can just maybe not get all the bids it should have gotten, or maybe just re-looked at bids and then could, until the day of performance or even after performance began, just walk away from the agreement. Why isn't that illusory? Well,
I think the illusory analysis is sort of an amusing common law mind riddle, but it's not really relevant to modern commerce. Convenience clauses are just ubiquitous. Look at your own credit card statement. And in the commercial context, termination clauses are negotiable. So whether it's illusory or not, that's a common law concept, but it's got no applicability in modern commercial context.
Well, contracts require consideration to be enforceable.
Of course, but there's consideration here.
What is the consideration?
The consideration is the 3 days notice. And there's numerous cases I cited in my brief. 3 days is not
It's non-mutual notice provision, isn't it?
It's non-mutual, but mutuality is not a requirement.
And where's the New Hampshire case that says that?
Pardon me?
What New Hampshire case says that?
There's no New Hampshire case that says New Hampshire that says.
Well, you rely on Smith, Batchelder, and Rugg on notice question, and that there was mutuality mutuality in that notice provision.
There was mutuality, but that's not the basis of the holding there. Rugg held that termination clause was okay, but it also...
Wasn't the consideration in that case really the employee's continued employment?
That's probably the consideration in that case, yes. But in the termination clauses in the commercial context, it's the notice provisions that are...
All I'm asking is where in New Hampshire law do we find that? What New Hampshire case?
Do we find what?
The proposition you just stated.
That
About
mutuality is not required?
No, where is the consideration in this contract based on New Hampshire law? You point to the notice provision and then rely on Smith, Batchelder, and Rugg. If we read Smith, Batchelder, and Rugg, find that the consideration in that case was really based on the employee's continued employment, what support in New Hampshire law can you point to for consideration in this contract?
There's no New Hampshire case, directly on point. So Rugg is as close as it comes. But there are numerous cases in other jurisdictions. There has to be some detriment for there to be consideration, and the detriment is the notice provision. 3 days is not as long as a week or 6 months, but the amount of consideration isn't relevant.
Could it be 1 day notice?
It could be if that's what the parties negotiated. In Hoban, this court said a peppercorn. So, a peppercorn is sufficient consideration. The amount of consideration isn't relevant. It's that there is a little bit of it. And that notice provision, the 3-day notice with which Ambrose complied, is the consideration. And
what is the detriment there? 3 days notice. That doesn't seem like much of a detriment.
It does not seem like much, but Hate Paint could have negotiated for more. That's the contract they signed.
But what is the detriment of 3 days? I mean, where's the detriment?
So they don't make their painters show up on the day of and just say, sorry, we're closing the gate on you. 3 days is some notice for the subcontractor to change its plans. And so it's a little bit of consideration, and like I said, the amount of consideration is not what's important. And in Hoban versus Caldwell Banker, this court said a peppercorn is sufficient.
Well, and there's a little more here, because if any labor and materials have been furnished, they get paid for that.
And Ambrose did pay it. The record says $1,300 or something like that was paid to Hate Paint.
So it's 3-day notice plus reimbursement for any costs that have been incurred prior to the notice.
Yes, I'm not sure the $1,300 is consideration, but that was complied with.
Right.
Yes.
Two of the questions presented in your brief deal with mitigation of damages, but there really isn't an issue brief there. So are those issues waived?
Waived. No further questions?
Thank you, Attorney Gordon. Attorney Gordon.
My brother said that my client shopped the contract around. That's just not the case. Another contractor sort of just showed up with a good price, and they didn't scheme to get a better price. That would be sort of like the Questar case. And price alone, getting a better price alone is not bad faith.
Well, scheming to get a better price is in the eye of the beholder. Here, it went back to Mr. Spinella's client several times, and I kept trying to get a better deal from that client, right? So
I meant scheming to undermine it, before the notice. There was, in Questar, for example, there's some of the government cases. There are intents to try to undermine the contract, and that didn't happen here. This was sort of serendipity where another contractor just showed up. The implied covenant doesn't apply, and that's central to the Centronics case, where there was a provision about how the escrows was going to be handled. And this court said that all that stuff about good faith in the decision, and it's a lot of it, doesn't really apply, because here there was an escrow, there was a provision, negotiated provision about how the escrow was going to be handled. I want to finish by saying, once more, Hate to Paint signed this contract. They signed it twice, and both times with the termination for convenience clause, in twice in two different projects. And it was free not to sign this. And Hate to Paint knew exactly what it was doing. This court should enforce it and revert.
But wasn't Hate to Paint entitled to rely on the fact that there would be good faith and fair dealing by your client?
There was no bad faith here at all. There was another contractor came on their job site with a better price, and that's what, there was no reaching out, looking for, shopping around, none of that happened.
Thank you very much, counsel. Case is submitted. Court will take a brief recess.